Good morning. The time is now 8:30. Order the second day of the June 2019 California Contractor State License Board meeting. I'm Marla Richardson, the board chair. Vice Chair Johnny, can you please lead us in the Pledge of Allegiance? Felice, can you establish a quorum? Take roll, please.
Marla Richardson. Kevin Albanese. Here. Frank Altamura.
Here.
Augie Beltran. David De La Torre.
Here.
Dave Diaz. Here. Susan Granzella. Here. Joan Hancock.
Here.
Mike Layden has an excused absence. Frank Shetter. Here. Johnny Simpson. Here. Nancy Springer. Here. We have a quorum.
Thank you. We're happy to be joined today by our colleagues with the Nevada Contractors Board. And for those of you that attended dinner last night, it was great. Nice to be able to discuss and just mingle with you all again. This is our 10th year in a row, so hopefully many more years to come. I will now turn over the floor to Nevada.
Good morning. This is the June 7th meeting of the Nevada State Contractors Board. The meeting is called to order. Let the record show that we have a full board with the exception of Mr. Lay, Mr. Wells, and Ms. McGuire. Ms. Green, have the notices been posted?
Yes, Madam Chair. The notice was posted at the following location: both offices of the Contractors Board, the Reno City Hall, the Washoe County Courthouse, the South Valleys Library, the Paseo Verde Library, the Sawyer State Building, the Clark County Library, the board's website, the Nevada Public Notice website, and emailed electronically to persons who have expressed interest in being kept informed of the board's meetings.
Okay, and would you like to read the mission statement of the board into the record, please?
Certainly. The Nevada State Contractors Board is committed to promoting public confidence and trust in the competence and integrity of licensees and to protect the health, safety, and welfare of the public.
Thank you. Is there any public comment for the Nevada board?
I would like to say happy birthday to Nancy Mathias.
Happy birthday to you. Happy birthday to you. Happy birthday, dear Nancy. Happy birthday to you. Any more pigeons out there? Any more birthdays?
Okay, now that we've irritated Nancy for the day, is there any other public comment for the Nevada board? Okay, seeing none. Ms. Green, I will turn this over to you and Dave to lead the discussion.
Dave, would you like to start?
Sure. For California Board, is there anyone that has public comment?
Okay. If you could turn to page 358. What we have in the packet is a comparison of our two boards. And looking over the comparison, there were some things that stood out that we could very well learn from our Nevada colleagues on. And the first would be the development of exams. It's my understanding that both California and Nevada develops their own exams, but one difference is that in California, we administer our test sites, and they are only located within the state of California. And looking at this chart, Nevada has test centers in Nevada, but also in 30 other states nationwide. So the question is, how is that working for all of you? Do you have any security concerns? Also, do you know how many examinations are administered outside of Nevada?
Thank you, Dave. And I will ask Ms. Mathias to come up to the table since she has that information in front of her.
Thank you and good morning.
Yes, Nevada contracts with PSI Exam Services to develop and administer our exams, and we've had a relationship with them for many, many years. It's been a really great partnership. We are involved in the exam development. We provide subject matter experts and ensure that the exams meet the requirements of our state. And as terms of the administration, they also have a call center. They handle all of the scheduling, as well as managing the test centers. Just about a year or so ago, we were looking at ways to reduce barriers to licensure. And one of those, we frequently had suggestions from out-of-state applicants, or requests, I should say, to take the exam in their own state because they knew they had a PSI exam center there. So we started to investigate that, and we found that PSI was willing to administer the Nevada-specific exam at any of their facilities, and they do own and operate those facilities. So we did not have security concerns about that. We were able to add an additional 186 exam sites in about 36 different states. And I believe, let me take a look at my notes. I believe about 16% of our applicants have taken advantage of that opportunity, and the majority of those have been from California.
So are there any questions from our board members of California regarding Nancy's statement?
So other than California, do you know what the next top state is that you're seeing a lot of the exams coming from?
The other two top states were Arizona and Utah, because a lot of our applicants come from western states. Mm-hmm. I was also mentioning to your staff last night that our arrangement with PSI allows for the exam fees to be paid directly to them as well. So we're not handling any funds related to exam registration, and we're not passing those funds through the agency. So it's a very clean arrangement that we have.
I have a question about that. So when they pay directly to PSI, you guys don't get any sort of compensation from that?
We do not. We have a no-cost contract with them, and so the arrangement is that they recover their costs through the payment of the exam fees.
And does that have any impact on maybe your license fee? Because I see that our license fees are drastically different.
It does not. There is a separate exam fee.
I have a question. How many exams did you turn over to PSI to administer?
Different types of exams?
Yes.
I don't know.
Okay.
There are quite a few titles that we have.
And how labor intensive was that to convey the information that was important in the exam? For example, the data that was in the exam, turning over to PSI, that must have taken some time to sync up with what you expected from the exam administration.
When we first implemented the program, we were with another vendor. And so we started to make that switch. It probably took us about 6 months to do all of the exam development. They already had a good pool of exam questions because they are an exam vendor for other states as well. But we had to round up our subject matter experts for each of the different titles and then go through that process. We were able to use the same pool of subject matter experts on a number of the exams because they had some crossover of scopes of work, but it took some effort. But once that was up and running, it's gone very smoothly. And then as we update our exams or add exams, of course, there's not as much effort involved in that.
Thank you.
Mm-hmm.
Nancy, could you address any of the security and exam breaches of security we've had on the exam? and the response PSI has provided for that and the action that they take when that does occur.
Yes, thank you. We've been very pleased with the security at their exam sites, and we have had some breaches of security, as you would expect. They document those and report them to us immediately. They also help us do any investigation that might be necessary for us to bring our case forward to either deny the application or take other action against that licensee or applicant. They do have, it's a computer-based testing delivery. They do have proctors on site that are employees of PSI, and they also have video surveillance and other types of measures in place for security.
Okay, one more question. What type of breach of security? Was it about individual applicants and what they had done, or was it your data was compromised in some way?
These have all been individual applicants who have either tried to bring in notes or other methods of cheating, or tried to take questions out of the, home with them, that type of thing.
Nancy, how many states use PSI?
I don't know, Ms. Cavan. A number of states do.
Because I know that the Board of Plumbing Examiners for Nevada also uses PSI for their testing.
They do. They also do testing for other professions throughout the United States, and that's why they have so many test delivery centers.
This is really, I think, to Dave. Have we ever evaluated the economics of subcontracting out our testing? I mean, our testing facilities and people are fantastic, but is there any efficiencies to be gained or explored by looking at somebody like PSI?
We've done a study. I'm going to ask Tanya to take the microphone next to Nancy. She's been taking the lead on that. Tanya Clark.
Hi, good morning. It's actually one of our strategic objectives. I'm just going to flip to find that right now. I believe that we're looking at presenting the study at the September board meeting, and certainly we're looking at evaluating what are the costs, is the benefits, and also consideration would it be to supplement as a recommendation possibly our current 8 testing sites.
So something else that we thought was interesting and that we could share information on is regarding bonding. The California legislature has asked us to study whether our $15,000 bond should be increased. And in doing that, we have to look at underwriting concerns. Does it pose a barrier to licensure? So our question for our Nevada colleagues is, have you considered raising your bond? Is it still $15,000? Does it apply to all classifications, even though you have a recovery fund for residential construction?
Thank you, Mr. Fote. Yes, we have, all licensees are required to post a bond at time of licensure. Our bonds range in value from $1,000 to $500,000, and those are set, they can be set at the discretion of the board. We do have a policy where we set bond values based on the monetary limit of the license. So most of those range between $1,000 and $50,000. That has generally worked well for us, especially since we have the recovery fund and other recovery methods for through our complaint process. But we do have the ability to impose a bond up to $500,000 if we think that's appropriate.
As a contractor licensed in both Nevada and California, I could attest to that. And, I hadn't thought too closely about it till you asked the question, but we struggle on the California side. You give somebody a B license and they could go remodel a bathroom and move a wall, or they could build a 100-story steel structure in downtown San Francisco, and there's no distinguishing. In Nevada, as my understanding is there's a monetary limit. So on our particular license, we have a limit, and please tell me if I'm wrong, of the largest contract we can take for that particular classification, and corresponding with that is a bond. So, maybe that's an interesting compromise to consider, because, if you're just doing bathrooms, you don't need a $50,000 bond. If you're doing a 100-story structure, you may want that $50,000 bond or higher, and you use the surety, you use that underwriting process to be sure that that contractor has that ability to do it. That might be a really interesting compromise, or something to look at that allows us to get a little bit more specific, because again, a B licensee can remodel a house or build a structure. An A licensee can go pour curbs and gutters for a city sidewalk job, or go build, Hoover Dam. And maybe that's a way to limit that objectively without running afoul of 7031. Thanks for bringing that up, and thank you for sharing.
Madam Chair, if I may. I am a big fan of Arizona's, how they have their bonds situated, and for the various different licenses. So that, if you want to go back and look at Arizona, we tried that in Nevada. Specifically, I tried it when I was chairman and it didn't go well. So I still am a big fan of it. I think if there's ever a time to do it, it's when the economy is good. Especially for us, we have license limits, so it wouldn't affect the smaller contractors. It just puts in place more secure for the bigger contractors. The one thing I would say, though, on bonding, that it's down later on the list, that if we could gift anything to California is our residential recovery fund, because it's a fantastic program. And it takes, that's what provides the backstop for the smaller contractors that can do quite a bit of damage, and we've seen that over the years, and it's a real bonus for public protection, especially on the residential side.
What is the Arizona model? Like, I'm familiar with Arizona's bonding model.
Nancy, I don't know it as well. For me, we have an AB, General Engineering, General Building, unlimited license, and my bond's $20,000. So I think that bond should be $90,000 or $100,000, right? It just provides more protection. For a license that size, it's inconsequential to any kind of cost. But it wasn't popular when I tried it, so I don't know that I don't know that we have the appetite to try it again. I may, but I don't know that we do.
Okay, I had just one other thing, and that's regarding workers' compensation insurance. I understand both Nevada and California have a requirement that a contractor have workers' compensation insurance. They have employees. In California, we have a mandatory requirement for roofing contractors. If they have an active roofing contractor's license, all roofing contractors, they must all have an active workers' comp policy. Our board is looking to expand that into other classifications. I'm just wondering if you've considered something like that, how your process works, and also how you manage the program. It's quite labor intensive in California, where we monitor workers' compensation insurance policies internally very closely. If they cancel, that results in the suspension of the license. We need a new policy. If they tell us they don't have employees, they can file an exemption, that they file an exemption from workers' comp certifying they don't have employees. Unfortunately, many of those exemptions are false. So we're interested to hear from Nevada as to your policy with workers' comp.
So Nevada has a provision that requires all applicants and licensees to provide proof of workers' comp coverage at the time we issue the license and at the time we renew it. So there's a period of time where it's not closely monitored. And similar to California, those individuals can file a certificate of exemption if they're not subject to those provisions. During the interim, however, we can suspend a license if we receive notification from the Department of Industrial Relations that they're not in compliance. But that's usually after an investigation that's been completed. They've determined somebody is not in compliance. They have not remedied that. They will send us notice. Our law requires that we summarily suspend the license until they remedy that. We have a number of those actions each year, but we are not required to receive cancellation notices from the policy issuer and to monitor it in that respect. That is not a duty that's been given to us.
If I could add a comment. excuse me. As an insurance broker, my job is to ensure that for the safety of the public. So in Nevada, we have a couple of different things that happen. First of all, we don't use the actual payroll, so there is a substantial amount of savings. So for those of you that do work in Nevada, the cap on the payroll to report for workers' compensation insurance is only $36,000. So if you've got people making in excess of that, you're not going to get charged any additional premium. The other area that we have concerns with, and I'm not sure how you guys treat it here, is the employer-employee relationship, where you have somebody that says they're an independent contractor. And in the state of Nevada, if you have somebody that's an independent contractor and they're injured and they don't have the industrial insurance or workers' compensation, it falls back on you. So you have to be really careful there. With regards to whether or not you have insurance or don't have insurance, when you file with the state in Nevada, there's a little box, and I tell people this all the time. There's a box that asks you specifically if you do or don't have employees. If you mark the box yes, then they're going to be looking for proof that you have insurance. If you have insurance and then you cancel it, or you mark that you have employees and you don't show proof, they're going to come after you. The minimum fine is $500. So we try to make sure we educate people on that in Nevada.
That's all I have for that section.
Are there any public comment, sir?
Just real quick, Eric Crandall from Cal State Contractors License Service. I do licensing in all 50 states. And the one thing I wanted to bring up about the Arizona bond was that Arizona requires you to provide a bond, but they don't, it's an estimate of your revenue. There's no check or balance. That's the only, I guess, downfall of theirs, because they have a, if you take a look at their website, they've got a good information as far as the bond is concerned. Excuse me. Allergies in Tahoe, much different. Anyway, so that's all I wanted to say, is that the bonding is different, and I agree they have some higher limits. Thank you so much. They have higher limits, which is good, but you're basically saying to Arizona, well, we're going to do $500,000 this year. There's no check from the registrar as far as what you're actually doing. That's all I wanted to say.
Thank you. Are there any board members for California that would like to place any item on our future agenda?
You know, as part of, I think, the September meeting, we're talking about the bond limits at the request of the Sunset Review. I think that's in September. Can I ask staff to work with Nevada and at least present what Nevada's doing on the bonding and the monetary limit? And maybe that's that opportunity for us to address the legislature's concern without creating an unnecessary barrier to licensure where, you know, we're trying to fit, you know, do a one-size-fits-all in a world that is just spans so many different economic levels and ladders and whatnot. It might be informational for the board, and again, it might not be, but I think that'd be really helpful.
We will include that agenda item and work with our colleagues from Nevada to put that agenda item together.
I have a question with regard to, where's Nancy? I think you said that Nevada had the option of raising or lowering depending upon the person or job, the business or job amount. Did you say that?
Yes, Nevada has a lot of discretion in establishing bonds, and we can do that based on the individual applicant. As you know, we do an extensive financial review on each of our applicants.
So my question before we go on is, it has more to do with whether or not payment and performance bonds are required on public works project, and that is something that's taken into consideration in determining whether you raise or lower the surety bond limit on that particular person.
We don't always know if the applicant will be performing public works jobs, but you know, they're certainly required to do that. There's also a provision that allows us to impose that requirement. We have a single project limit increase provision, and If we grant that, we always impose a payment and performance bond requirement. We can do it under other conditions or situations, maybe in disciplinary proceedings, establish higher or stricter bond requirements if we think somebody needs to be monitored more closely. So we do have a lot of discretion. In general, for most applicants, we simply base the bond on their monetary limit.
So what I'm thinking is on some of those public works projects is the surety, right? That is designating whether you as a contractor, I'm going to use you for example, Kevin, are, depending on the size of the job, are going to be required to post a bond so that, you get where I'm going with all of this, is whether or not one is relative to the other in determining, whether we raise or lower our bonds.
I think I understand that, and yes, I mean, on public works in California and Nevada, you have to have a payment performance bond. So the license bond, I don't know, would be much help, but if you're doing large public works jobs, if the state of California wanted a $100,000 bond, and your surety limit with your, on your regular program is 5 or 10 million, it's a nit. I mean, like Kevin said, it's an absolute nit. So, that project mix may be important, but at the end of the day, I think at the governing level, the size of the job that you're doing and your financials. I don't know that I mean, when you look at the numbers, you look, what do we have, 285 active license, 1,000 actives? Yeah, or 230 active. 50. It's I don't know that we have the scale to be able to do the kind of analysis that Nevada does, but we could certainly do something a little bit more custom, to again stratify the A's, the B's, and some of these other specialty trades without creating a barrier to licensure. Does that answer?
Yeah, it's just a thought I have about how they're really operating and whether or not, it's duplicative when you're bidding on public works projects versus the licensing bond. When is it actually going to be used? When is somebody going to go after your licensing bond, really, if you're doing a public works aren't they going to go after the performance bond if you fail to, if you walk away, if you don't complete? I mean,
I agree with you 1,000%. On those public jobs, the license bond would be immaterial. That license bond is really to protect the consumer or that private party that's not getting surety as part of their projects. But again, if you have a large public works program going within your business, to get a surety bond for a license bond up to $100,000 would be an absolute. I agree with what you're saying, but I think the practicality of it really wouldn't matter, because the premiums for a license bond are not. They wouldn't get in the way. If your surety's going to underwrite you a $10, $20, $30 million bond to go build a highway, they're not going to squawk at a $100,000 license bond.
So now we're going to turn the floor over to the Nevada Board. Margaret.
Ms. Green?
Thank you. While the majority of our information on the comparison sheet remains similar to our last meeting, I thought I'd highlight a few changes for Nevada. We've noticed an increase in our licensing data, and that reflects an increase of about 4% for active licensees. Our license count remains about 16,000. Compared to last year's report, we saw a 10% increase in the number of new applications for fiscal year 17-18, and we're going to exceed that this fiscal year as well. We also saw an increase of 1.5% in our license renewal applications between 2016-17 and 17-18. There have been no changes in the board's fees, bonding, and insurance requirements or criminal background processes, even though many of these issues became a point of discussion during our legislative session, which just ended earlier this week. and I'll touch on that later in the agenda. We will also address in our discussion our efforts to reduce licensure barriers, and we've expanded our exam endorsement program, as Nancy mentioned, to include 13 states. Our number of complaints increased slightly, and while unlicensed complaints increased about 15%, complaints against licensed contractors 4%. Again, we're expecting this year will probably be double that amount. We did experience some changes to our recovery fund, which I'll address in our legislative update. During last year, we awarded nearly $404,000 to harmed consumers. The board revoked 40 licenses, and that was down a little bit from the previous fiscal year. Then I'll go ahead and discuss our efforts and with regard to reducing barriers to licensure. As you may recall from our meeting last year, I gave a presentation about the National Occupational Licensing Consortium and its goals to reduce barriers to licensure and improve license portability across 34 selected occupational licensing professions. Nevada is one of 11 states that's participating in this 3-year study, and it's the only state to have 2 occupational licensing board executives on that team. The program will conclude at the end of this year. The initiative was funded by grants from the U.S. Department of Labor and is supported by the Council of State Governments, the National Conference on State Legislatures, and the National Governors Association. The funding is to assist states across the nation in their efforts to review and streamline occupational licensing rules, as well as to eliminate or reform licensing requirements and to promote the portability of state licenses. Among these initiatives are specific calls to action regarding reducing barriers for veterans and transitioning service members. Across the nation, states are evaluating their licensing requirements in high-demand occupation areas such as transportation, healthcare, protective services, and mechanical and construction occupations. Initially, Nevada's team focused specifically on HVAC, plumbers and pipe fitters and steam fitters, nursing assistants, and LPNs and LVNs. It was expanded earlier this year to include cosmetology. So over the course of the meetings held in the past 2 years, we have shifted Nevada's focus to developing strategic initiatives that seek to support workforce development efforts through concepts like reducing barriers to licensure and license portability. So in addition to the consortium initiatives, I was brought on as a project manager for the Federation Association of Regulatory Boards, known as FARB, to assist in their Super Strategic Action Team, or SuperSAT as we call it, in developing a national message to promote regulation and engage FARB members in its leadership summit next month. The SuperSAT team is charged with developing an authoritative message for state-based regulation by identifying relevant constituents, addressing current realities, anticipating future contingencies, and formulating a platform that establishes the basis to the development of resources and tools for FARB and its members to achieve the goal of informed political, practitioner, and consumer base. Throughout the occupational licensing reform movement, which is taking place in many states across the country, FARB has been an instrumental resource in helping various regulatory bodies and respond to this anti-regulatory sentiment. In that light, the SuperSAT was created to bring FARB members a unified and consistent message that could be used to clearly and distinctly identify the role and purpose of regulatory bodies across the nation. We have since developed that message and are currently working on our workshop for next month so that we can pass this message on across the country for a variety of licensing boards, going down from the boards, the national boards to the state boards, and down to consumers and constituent groups and legislative parties as well. So those are just a couple of actions that are taking place at a national and state level that will reduce the barriers to licensure and then promote sound regulation. However, I also want to share some of the actions our board has engaged in, just as in the state of Nevada, to address some of these initiatives. And for the rest of that discussion, I'd like to turn it back over to Nancy, our licensing administrator, who will share with you the board's efforts during the past year.
Hi. So as Ms. Greed mentioned, over the past couple of years, we have focused a number of our efforts on reducing barriers to licensure and improving portability. I think it's important to note that we have not changed our standard for obtaining a license. Each applicant still is required to demonstrate a certain level of experience, financial responsibility, and good character. What we have done is looked at other ways in which those applicants might meet those standards. And then in addition to that, we've looked at ways of improving and simplifying our processes where we think that might be appropriate. One of those areas was our Licensure by Endorsement program. This program is the result of legislation that was passed in 2017, and then subsequent program and rule changes that were enacted by the board. The focus of this program is really on two of the requirements for licensure. One is the experience qualification, and the other is the trade exam requirement. In developing this program, we looked at the licensure requirements, scopes of work, and trade exam requirements in Nevada and compared those with other states to determine where there might be substantial similarities. As a result of that, we found similarities in at least one or more areas with 13 other states and have been able to expand to recognize those states. We've published a list on our website so applicants know whether or not they should seek endorsement or if they may qualify for that. In order to request endorsement, the applicant must be actively licensed in the endorsing state for the past 4 years, not have had any disciplinary actions or suspensions imposed on their license, and have passed an equivalent trade exam or take Nevada's specific exam if the trade exam is not equivalent. It's been a well-received program. To date, approximately 14% of our applicants have taken advantage of that. The largest percentage of those have been in the general building, general engineering, and electrical trades. In addition to that, we recently modified our regulations to allow the board to accept additional types of proof of experience qualification. For many years, we have only accepted reference certificates. Now we're able to look at whether or not somebody holds a master's certificate in a comparable trade, and then also for our veterans, transferable military experience as well. We just recently adopted those regulations, and so I really don't have any information as to how effective they are yet, but we're looking forward to implementing that program. One of our ongoing initiatives is to continually evaluate our internal processes and look for ways that we can improve and quite simplify how we do things. One of those we talked about earlier this morning, and that was working with our exam vendor to expand opportunities to take the exam in other states. That's been really well received, and it's provided a savings of both time and travel costs for many of our applicants. And so we're pleased with that program. We also have implemented several years ago a criminal background interview process. So if we have somebody that we might be considering for denial, our enforcement staff will interview that individual to get a better understanding of the nature of the crimes, any efforts to rehabilitate what's taken place since then, and we'll make recommendations concerning whether we should move forward with licensure denial. That program has reduced our denials based on character by about 80%, so it's been very effective for us. Also, our Small Business Assistance Program continues to be very popular for first-time applicants. We offer that seminar twice a month, and we provide assistance in completing the application forms, providing resources and other information that new business owners need. We're also moving toward developing some online content and webinar to enhance that program. It has all, I think it's very much appreciated by those who are intimidated by the application process. And so we look forward to enhancing that as well. Our legislative package this year included several measures that address licensing that we believe will reduce some of the barriers as well. It allows the board to reinstate a license without penalty for members of the military or National Guard whose licenses expired while they were on active duty. It increased the period of time that a license can remain on inactive status from 5 to 8 years. We increased the time frame for consideration of experience from the immediately preceding 10 years to 15. And then we also removed a requirement that Nevada had that required contractors who perform residential work to provide a financial statement and undergo a financial review on the first and second anniversary of licensure. As we looked at our requirements, this stood out as one of the most burdensome. We conduct about between 800 and 900 of these a year, and our failure rate was only about 1.5%. And those were usually people that were not responding to us, and then we had to take action against their license. So it requires a CPA-prepared financial statement. It was very costly for the licensee, and it was taking a lot of staff time as well. And we were successful in having that provision removed, and so we'll be able to redirect those resources in other areas. And then finally, we'll be talking about this in a minute, but we've put a lot of effort into revising our application forms and our renewal processes and that sort of thing. So while it's hard to know which of these efforts have been most successful, we have seen a reduction in our processing times. Between March 30th of last year and this year, even though our applications increased by 17%, our processing times were reduced by 38%. So we're really pleased with the initial outcomes of these efforts and look forward to continuing those. Happy to answer any questions.
What is the average processing time for an application?
Currently, it's about 57 days, and we measure that from the time we receive the application until we either approve or deny it.
Hello.
Yes, go.
I was just doing some quick math on here. When it comes to complaints, it looks like you're almost double what we are on licensed complaints. I just was wondering why. Maybe it's easier to report in Nevada or something. And then also, when it comes to being revoked, you're double ours percentage-wise on revoked licenses too. And I'm just kind of wondering why. I know I'm taking a guess that it's probably not that we have better contractors, because I doubt that. So, just wondering.
I don't know if we can really comment on that, but Mr. Rosario, would you like to come up and comment? Mr. Rosario is our Director of Investigations, for those of you who haven't met him before.
Good morning. Yeah, the complaint, I don't know regarding California side, but I can tell you what's happening in Nevada. with the uptake in the economy, there's more home improvement projects that are being done, which is because of that, there's going to be more complaints that are coming through. Unfortunately, with those complaints, most of them are workmanship, which take more man hours and investigative hours to address, and that is concerning to us because of just the limited staff that we do have. Regarding the revocations, our process is, I think it's probably more timely. It's not, I don't want to say it's easier, but it's maybe more efficient and to revoke a license with us. We do everything is internally. We don't go outside to a third, like an adjudication body. Everything is done. We can, through the executive officer, has the ability to summarily suspend a license. Within 30 days, a hearing is held. At that point in time, the license can be revoked. So probably, I think the soonest that we can, from notification to revocation, excluding if we do provide an extension for that hearing, but you're probably looking at anywhere between 45 to 60 days for revocation of a license if we feel it's justified.
With that uptick in complaints over here, there.
Oh, sorry.
Sorry. With that uptick in complaints, do you guys have a way of tracking whether those are contractors in state or out of state?
Those are licensed. Well, those are licensed contractors, as well as we can track whether it's a licensed contractor
But
or
are they
a licensed contractor.
those that have migrated to your state from other states that have obtained their own license? Do you have any way of tracking that?
We haven't tracked that. No, I don't think there's potentially maybe a way to look at each individually and go back and track it, but we have not tracked that. No.
Well, just to confirm, we moved on to agenda item C2. I'm just trying to follow along here. A lot of California's taken a lot of the same steps that Nevada has to reduce barriers to licensure. We are having monthly license workshops. We have them held in Sacramento, also in Norwalk. They've been very successful. We have reached out to schools and others like Eric Crandall. We had a meeting last week which was very beneficial, and working with the schools and other licensed private entities that are engaged in helping people to either become licensed or maintain a license understand the rules. So that's been a real focus to make sure that it's understood what the minimum qualifications to licensure are. What we did talk about on the agenda and also in the packet is the Little Hoover Commission. The Little Hoover Commission is a state of California commission that it provides private oversight to government, and they came up with certain recommendations. And one of those recommendations is that we would look at criminal convictions. In the report, it states they talked to various witnesses, and the witnesses reported that there's not a direct correlation between a criminal conviction and the quality of the work. That's resulted in a number of bills that either have been chaptered or pending that would impact our ability to review an application to see if somebody's qualified for licensure. As I think most of you know, one of our primary concerns in reviewing a complaint is the financial aspects. We do get a lot of workmanship complaints in California, but the consumers that are harmed significantly, it's because of money being taken in advance of the work performed. Sometimes the work's never performed, or there's not funds remaining in the contract to hire another contractor to complete or correct the job. I would ask our staff counsel, Christy Shield, to comment on some of the bills that would reduce barriers to licensure, but also would impact our ability to review somebody's criminal background for licensure.
Good morning. I'll turn your attention to page 363 of the packet. And so, as Mr. Fote mentioned, the Little Hoover Commission made a bunch of recommendations on removing barriers to licensure. They included some of the things the Nevada boards mentioned about addressing veterans and military experience and counting that towards licensure. Those bills have been enacted, but we also have a slew of criminal conviction, criminal background type legislation that's been enacted or is pending. So the most significant piece of legislation is Assembly Bill 2138, and that bill reflects a significant public policy change in California and how we process licensing applications for boards in California. Currently, there's no time restriction on how far back we can look at a criminal conviction, how recent it is, what type of conviction it is. There's no restriction. Each board develops its own criteria and determines whether it's related to the profession and whether that crime evinces potential risk of public harm to public health, safety, and welfare. The bill, which will go into effect July 1st, 2020, will change that. It will put a time restriction on most crimes that the board may consider, and it will pin them at 7 years from the date of conviction. So you can't go back 7 years or later for any conviction with few exceptions. So that's a huge change that has, going to impact potentially consumer protection in California, but also allow more people potentially to enter the profession. In addition, I don't know if Nevada does this, but on our licensing applications, we ask whether you have had a criminal conviction. And in this state, another state, a U.S. territory, or a foreign country. So it's quite broad, and it allows sort of an additional check on what we call the criminal offender record information, or the rap sheet that we get from the FBI or the California State Attorney General Department of Justice. In our experience, sometimes the rap sheet's not accurate. Doesn't include all the information because the FBI rap sheet sometimes it's dependent upon the jurisdictions reporting the information to the FBI. So if the FBI doesn't get all of the criminal conviction information, the board may get a clear FBI rap sheet, and then the applicant will report 10 to 12, and it's happened, convictions. And we'll check and pull those criminal records, and they will have convictions. So this legislation will prohibit the boards in California from asking that or requiring the person to report their criminal history. So we'll no longer have that question on the application beginning July 1st, 2020. So it's called a ban the box policy in California, and we've seen that in employment. We've seen that in state employment. Now we're seeing it for licensing purposes. So that's intended, again, to allow people to show that they can perform with safety without legislatures considering a barrier to licensure. So those are significant changes because the board will have to potentially do its own independent investigation if it gets reports externally, and sometimes we do from people that someone has a conviction. So we'll be relying on those sources, and we'll be relying only on the rap sheet to do the criminal background check. So that's a significant change. And then if you see some of the other legislation listed here that's pending, probably to me the biggest one is Assembly Bill 1076 at the bottom. That bill would, if it were enacted, require the California Department of Justice to remove criminal convictions from the rap sheet if people meet certain benchmarks. So if somebody has a misdemeanor conviction and they haven't reoffended within 2 to 3 years after the conviction, that would be removed. If you have a felony and it requires only county jail time, that would be removed after 2 years from the date of release from incarceration or completion of the sentence. And if you've been arrested and you're not convicted within that 1 year following the arrest, the arrest would be removed from the rap sheet. So even though we have the restrictions currently that would be going into effect July 2020, AB 1076 would remove the information from the rap sheet. So again, there's this public policy shift towards allowing people for entry into the profession. It wouldn't affect our ability to get information on licensees, but it would affect our ability to screen applicants using a criminal background history. Any questions?
Yeah, Christy, I have one. Does
Sure.
that include all classes of crimes with murder and some
No,
more?
there are a few exceptions, like I said. For AB 2138, the exceptions are serious felonies, and that would include rape, robbery, murder, attempted murder, arson, and it would also include repeat habitual sex offenders. However, it would exclude all misdemeanors, so even sex offender registrable misdemeanors. So sometimes you'll get, a rape arrest, and it'll be pled down to sexual battery and a misdemeanor. They'll have to register for a period of time, but under this law, 7 years is as long as we can screen for a sexual battery misdemeanor. So there will be some crimes that we typically would actually hold people to a higher standard, like we'd issue a probationary license to monitor for a while, or there may be a denial. Because of the time restriction, there may not be that opportunity for applicants. For licensees, that's not the case, but for applicants, it definitely will affect our ability to screen that and the entry to the profession. For AB 1076, again, it's pending. We don't know if it's going to go through, but it would affect all misdemeanors, for sure. Felonies, no. It wouldn't affect the serious felonies. Any other questions?
Yeah, one question. Does the board take an official position on either one of those boards?
We did take positions of oppose on the legislation, but it was signed by the governor. So, I think all the boards in the Department of Consumer Affairs opposed it. But like I said, there's been this movement towards giving people this opportunity for entry into the profession. There hasn't been a movement to change it for people who are in the profession that do get convictions. We still have the same authority that we did previously or have currently. But it's this, like I said, a public policy shift towards removing barriers to licensure to allow people to get that second opportunity, kind of considering in some instances in the bill, in the legislation, it talks about if you've successfully completed parole and probation. So they're kind of treating the parole and probation completion as evidence of rehabilitation.
Yeah, and then one other question. In this commission report, the Little Hoover Commission report, did you all debate that and the findings of that? Because about halfway down, it says the report found the occupational licensing requirements designed to prove a proficiency often serve as a gate, keeping people out of the profession. And I personally would say ... probably because we should keep them out of the profession, right? I mean, that's...
Right. Well, it was interesting. A lot of my board clients, and I believe this board did as well, participated in those Little Hoover Commission hearings, because what happens is the Little Hoover Commission holds hearings, and they invite the public and state agencies to attend and provide that debate, as you've mentioned. So a lot of the clients did go, and they discussed it, and the commission agreed that there are instances where that is really necessary. But they did believe that there were several instances of witnesses, as Mr. Foat mentioning, that were harshly treated and had demonstrated years of rehabilitation. And the emphasis was often on DUI and drug-related convictions, which we use sometimes to place people on probation to monitor for substance abuse issues, because that affects competency. But there was a lot of tales of people being denied licenses or placed on probation for convictions that had happened 10 years ago with no reoffense, no recurrence, and great community service and track record of contribution and work in the community. And they felt that they were harshly treated and kind of were given a scarlet letter and weren't allowed to start over. And because all of our actions for probationary licenses are posted on the internet, people would complain about how, well, look, I've already been punished and you're punishing me again. So there was that sort of talk that was really powerful to the Little Hoover Commission. I think they were trying to say that we need to look at the way we're currently processing applications and really put an emphasis on if someone's made a showing of rehabilitation, and it says this in the legislation, they shall not be denied a license. So we are being required to reevaluate our criteria, make improvements so that it's not just, you have that kind of crime, you're denied. And that was the perception, even though I don't believe that's the way that the board is operating. That was the perception. So that was the successful public policy argument that prevailed. And so we're kind of on that track of, let's give people, if they show they're rehabilitated, they haven't reoffended, they have a clean record since their conviction occurred, they haven't violated parole or probation, they should be given an opportunity to show that they're, worthy of being licensed and in the profession.
Just to that comment, and I agree with you 1,000%. The Little Hoover was not just the license board, but all occupational licensing, and I firmly believe in what we're doing, and I think our board does a great job. But a lot of our discretion is taken from us through statute, through regulation. We don't have the same discretion that Nevada has to where, if we have a bad actor, it takes 1.5 years to probably pull their license. Is that reasonable? And what really illustrated that, can you hold up your book? And Madam Chair, can you hold up your book? That just, again, a lot of our discretion has been taken from us as a board. And so I think the Little Hoover's trying to balance some of that, where, if we have that better discretion at the officer level, we can help some of these people that really should be licensed. And there's people that are licensed that shouldn't be, and there's people that are not licensed that probably should be. And that's a challenge we face.
We will want you to keep that book here in California when we go right across state line.
I do have a question, clarification, if you could. So I'm not real clear. So you can't go past the 7 years, period?
Well, effective July 1st, 2020.
Okay.
Anything that's 7 years or older.
Regardless of the crime?
Except for
With
the exceptions
certain
for the
ones that you said.
serious crimes like murder, rape, robbery, arson. There's a list in the penal code. They have a cross-reference to it. There's also felony financial crimes the board has developed by regulation involving theft, dishonesty, credit identity theft. Those won't have a restriction. And then the repeat habitual felony sex offenders, not the misdemeanors.
Okay.
So the misdemeanor sex offenders, 7 years or greater, we won't be able to use those convictions.
So with that being said, you understand there's several states, including Nevada, that are now allowing felons they're giving them some of their rights back.
Well, that's what I'm saying. The public policy shift is significant here. And I think it started with the 2015 U.S. Supreme Court decision for the North Carolina Dental Board examiners versus the Federal Trade Commission. That's what sparked the Little Hoover Commission study and report. And so since that time, we've seen a lot of public policy examination of how we license and how fair the licensing process is, how onerous and burdensome it is. There's been focuses on specific professions, but these bills apply to all the professions in California.
So what Mr. Rosario has done and staff has done, which has worked really well for us, is by doing those personal interviews, and then when they come before us because the license has been denied, we're able to look at them in the eye and make a determination. We have a little more leeway because we have what's called moral character, so that gives us a little bit more. It's not so strict. It's a little bit more subjective. So if we determine based on the personal interview and then the hearing, whether we can determine at that point whether we feel that person needs a second chance or not. So I, as a public member, am always concerned about how we appear to the public if we do allow licensure to some of these people, as you were saying, that we feel their moral character does not justify it. So I think we've done a great job. I think the board takes a really, really hard look at that before we make a final decision, and we don't always agree, but in most times I think we're very fair about determining whether or not, like you said, the person has paid their dues and it's justified to give them a license again. So we'll see how that evolves as all of this public policy changes coming down the road here.
Just to clarify, in California, we used to have the moral character standard, but the courts threw it out in favor of what's called the substantial relationship test. and the rehabilitation tests. So we first have to establish that the crime is actually substantially related to the profession. It can't just be any crime. It's got to be something that shows that while you're performing that profession, it could affect public health, safety, and welfare. So, protesting at and being arrested for unlawful assembly because you protested the Vietnam War is not probably something courts would think was related to contracting. So it's those kinds of standards, those are more objective, but it's the same concept with rehabilitation. So we call it rehabilitation criteria and evaluation. And so the Little Hoover Commission claimed that we fell short on that second prong, that we really didn't look hard enough at the evidence that the applicant provided to show that they had rehabilitated, the time that had passed, whether they had done positive things in their community, whether they had gotten their conviction set aside or dismissed and gone to court to prove that they had rehabilitated. We didn't consider that. And so, I don't think that's true for all of our boards, including ours. Everyone kind of got the same standard put in place. We have to focus our energies on whether someone's made a showing and to demonstrate that they did not make a showing of rehabilitation in order to justify the denial.
Christy, I had one comment for you. Many states, including Nevada, passed legislation that allow a person to petition to a board if their criminal history would disqualify them from obtaining a license. Did that same bill pass in California?
I'm not aware of that, but we currently already have a hearing process for every denial. They get a full qualitative adjudicative hearing if they want it when they are denied a license, and it's before an administrative law judge. They are allowed to bring an attorney. It's litigated. There's a proposed decision. It goes to the registrar. And if they want to, they can appeal to the full board. So there's so many multiple levels of review. And there's something called Petition for Reconsideration, which they can do. It's an administrative appeal process.
This particular process allows a person to get a ruling before they apply for a license, so that if they have a criminal background or criminal history that might prevent them from getting a license, that they can petition the board. We were successful, it just passed in Nevada. We were successful in getting the Contractors Board exempt from that, but the rest of the boards did not. So.
Good for you. Yeah. Well, that would be sort of like that would be a double hearing process for us, because we have multiple administrative appeals, as you've seen here, for people. So they get a lot of due process in California, which is why it takes so long to move sometimes applications through the process, or even disciplinary cases. We have some suspension authority, but the bulk of it is a full adjudicative hearing with multiple administrative appeal rights. So we haven't seen legislation like that yet, but who knows? With the way that the policy's going in California, that's always a possibility.
Okay. I would ask that Justin Paddock, our Chief of Licensing, come up and talk about the increase in applications that we've observed in the last few months. I believe we've gone from 1,000 a month to almost 1,400. How you're handling that workload, and also, I guess your success with Louisiana in achieving an exam waiver, and some of the challenges you're experiencing in achieving exam waivers in other states.
Certainly. So since fall of last year, we certainly have seen an uptick as late as December, which is usually a slower time for us. We saw a 22% increase. Now, starting in 2019, we're actually looking more at a 39% increase in paperwork. Our goal is to turn around anything that's submitted to us within 2 weeks, make sure all the processing is done, and you have a response from us about whether we need additional information, et cetera. We've been doing quite a bit of overtime, basically to meet that requirement. So thankfully, I've got willing staff that are doing Saturdays and doing long hours during the week to keep our processing timelines down. But we have experienced a significant increase. With that, through the process, we've also made a few efficiencies. Did you want me to speak to those as well? With regards to the workshops that David mentioned, we have one, as he has said, in both Northern and Southern California. We have a session in English and in Spanish, and anyone who wants to participate in that gets my direct line, so that if they fall along the way in the process or something gets confusing, then I can match them up with the right person, make sure that they get back on track to getting their license. That has been immensely helpful, just because I think it's also improving our overall timeline from when you start to when you finish. With that, we're also accepting more forms of evidence when we're looking at your experience. Again, we're looking for 4 years in the past 10. And with that, when it comes to criminal background reviews, anyone who I would consider a wobbler, so it's unclear whether or not this is going to be an approval or a denial. I am speaking with those individuals. A lot of individuals have trouble just appreciating what rehabilitation is as a concept, and so if I can have a conversation with them and really talk to them about what's changed, that's usually helpful. So those are some of the efficiencies we've experienced. In addition, there's a lot of test anxiety when you're getting to that part, and so we're trying to alleviate that by just making sure we have conversations with individuals, and sometimes with their significant others too, to see if there's any sort of accommodation that we can meet to make sure that on exam day their head's in the game. So those are some of the efficiencies we've implemented. Before I joined the board, we actually entered into a reciprocity agreement with Louisiana. I do not have the specific statistics on that, but I certainly can provide them on how many applicants that we've gotten from that state. We've also attempted to enter into a reciprocity agreement with North Carolina, but some of the difficulty there was, in addition to accepting the NASCLA exam to be a general contractor in North Carolina also has its own specific trade exam, and it's difficult to evaluate that exam in detail. And so at this time, we're not pursuing a reciprocity agreement with North Carolina. Our hope at the NASCLA conference that David will be attending later this year is to promote that anyone who wants to start using the NASCLA-only trade exam, please make sure I'm your next call so that we can talk about entering into a reciprocity agreement. There hasn't been a lot of nationwide adoption yet, but I'm hoping that that changes. Were there any questions?
Thank you, Justin. That would be our update for the agenda item C2.
Ms. Green, you've pretty much touched on all of these. Is there anything that you need to add under C2?
That would be the legislation. So I'll quickly go over some of the highlights from our legislative session, which just ended this week. We wrapped it up just this past Monday at midnight, and we did have some successes that we'd like to share that happened. We sponsored 4 bills just from the Contractors Board. We did that early on, pre-filed them. The first was Assembly Bill 25 regarding changes to licensure and reducing barriers, with which Ms. Mathias touched on during her presentation. The next was Assembly Bill 26, which changed our residential recovery fund from the payout from $35,000 per consumer to $40,000, and also increased the maximum aggregate amount per contractor from $400,000 to $750,000, or 20% of the recovery fund balance, whichever's less. That stemmed from some large cases that we had over the past few years where the contractor exceeded the $400,000 limit, and the fund was healthy. However, we could not assist many consumers in that, so we went back and got that legislation passed, and that became effective October 1st. Our third bill was Assembly Bill 27, and that changed some of our processes for cease and desist orders. We initially started out just putting in an appeal process for cease and desist orders, which we didn't have. However, when the bill was first heard in Assembly Commerce and Labor, there was much interest from the industry about that we're not doing enough against unlicensed contractors and enforcing those cease and desists. So I worked very closely with many of the proponents of the bill, legislators and industry representatives, so that we could strengthen the language and without compromising the original intent of the bill. So that this process still allows a person to appeal a cease and desist, but again, It allows the board to go back and ensure compliance with that cease and desist order within 48 hours. And if they don't do so, then the penalties increase significantly. There's criminal prosecution. And Mr. Rosario, when he does his presentation, can highlight on that. That became effective on May 14th. It was effective upon passage and approval, so we quickly had to get processes in place to implement that. But the industry initially expressed dissatisfaction in that process, so we worked with them, got it so that it's something that will work for all of us. We're still working out the bugs in it, and I think the unlicensed contractors are going to have a rude awakening when this gets into place, in my opinion. Assembly Bill 29 was our final bill that we had, and again, this allows a general building contractor to hire one general building contractor as construction manager or another construction contractor for the project. This stemmed from a change we made back in 1997 to kind of mirror California's law, only ours got a little bit more convoluted, and there was some unintended consequences with that. Again, there was a lot of interest from the industry about changing it. The wording that came out is a little bit more convoluted than we initially intended, but it serves the purpose, so that bill was passed as well and became effective on May 14th. We did have a change to prevailing wages in Assembly Bill 190, which I won't talk about too much. Assembly Bill 421 was this year's version of construction defects in Nevada. So the original bill included a provision that required general commercial liability insurance as a requirement for all licensed contractors. In looking at our statistics, and we do have license limits, so this imposed limits for those that had $1 million or less, had one range of insurance, $1 million to $10 million, and then $10 million to unlimited. So we did all of our analysis on it and found that many contractors would have been harmed by this legislation, could not afford the insurance requirements that they were setting, and also we felt it would increase unlicensed contracting activity. Some of our applicants couldn't qualify for the additional insurance. Our current licensees may not qualify. So we were successful in getting that removed from the bill. And we were very fortunate that that didn't take place, and that was a win for us as well. That bill was enrolled with the governor. I'm not sure as of yesterday if it's been signed or not. I just read this morning that he signed a couple of hundred bills yesterday, so I'm assuming that was one. Assembly Bill 440 was another bill that started out. It was concerned warranty issues. So this will require a licensee who builds a new single-family residence to provide the purchasers a disclosure containing certain information, which we already have in our current law, but it also requires them to provide a builder's warranty that meets certain criteria. If they fail to provide that or don't comply with it, then the Contractors Board is required to discipline the licensee for that. And that bill has been signed by the governor. Senate Bill 371 was also approved by the governor and allows unlicensed individuals to perform work on manufactured homes as long as the work is valued under $1,000 and is not structural. It also allows for a contractor who's licensed under 624 to perform work within their classification on a manufactured house, as long as the work does not impact the structure or fuel systems. It also directs the Manufactured Housing Division to turn their complaints over to us if it involves a licensed contractor for further investigation and discipline. We were successful in amending that bill so that it was something we could work with. Initially, it was very confusing as far as who was regulating manufactured housing. That was something that we did not want to take on, but we were satisfied with the amendment, and that bill becomes effective July 1. And then finally, Senate Bill 397 allows a contractor to perform work that's under $1,000, does not require a permit, and is not a life safety trade, to perform work outside the scope of their classification. That was a bill that the home builders wanted. We worked with them again to modify the bill, and that becomes effective July 1. And then Mr. Rosario is going to speak a little bit about Assembly Bill 465 concerning solar. I just handed him the bill a couple of days ago and said, read it and be ready to report on it. So I'm anxious to hear his report as well. And with that, I can turn it over to Mr. Rosario unless there's any questions.
Yeah, what do you guys define as a pre-manufactured house? Is it like a mobile home, or is it modular?
You said manufactured.
Manufactured.
Manufactured, yeah. What, in California, we've got, and I know other states, they have factories that build components. They build the homes in components and then put them together on site. Is that what you're looking at, or are you looking at like mobile homes, or?
It's not the mobile homes, and I don't know if one of my staff members wants to expand on this. Fred, you're the one that knows all about manufactured housing. This is Mr. Schoenfeld. He is our investigative supervisor from our Reno office. Thank you, Fred.
Yes, ma'am. I'm certainly not an expert on it. I know that I've been working with manufactured housing in the state of Nevada for quite some time, and it's always been a question, what's manufactured housing? The latest that we came up with, I mean, manufactured housing is manufactured housing, so what's the difference between a mobile home or a modular home? And it was determined that a mobile home is basically, is personal property, is tagged much like a motor vehicle with a VIN number, that sort of thing. Modular home is inspected in a factory where it's constructed, such as Idaho. Turns out a lot of modular homes, and those are inspected there. I can't tell you what kind of inspection it is, but our local authorities never inspect those. Also, modular homes, which are manufactured, are brought in on basically not permanent frame and axles, whereas a mobile home is. To us, they're all manufactured homes. You brought up the point about the component system, and I guess I'm talking to the right person, but the component system that's built, although that's pre-manufactured, it's not an entire building. So when they bring that in and they put it together, that's inspected by the local building authorities, and that becomes under our jurisdiction as a stick-built home. Does that help?
That makes absolute sense.
Thank you.
Thank you.
Thank you, Fred. Any other questions?
Hi, just real quick, Mike Jemetsky, Legislation Division for CSLB. I just wanted to ask the bill number of the bill you were successful removing your commercial general liability requirement for contractors.
Assembly Bill 421.
Thank you. And then you had mentioned life safety trades in the context of your SB 397. How are you defining life safety trades? Is that statutory or?
It's statutory. It's plumbing, HVAC, fire protection, electrical. I think that's all. And if the board determines that something else is life safety, we would.
All right. Thank you so much.
Oh, thank you.
For California, for some clarification on those different definitions on manufactured home, mobile home, and then factory-built housing. So when you have built elements like that, we did it in the 90s. It was a big thing. Haven't seen much of it going on anymore, but Housing Community Development for State of California has some informational bulletins on that and can explain it. Same with tiny homes, where they've spelt it all out. They've kind of clarified more as to manufactured mobile homes. We don't call a manufactured home is the kind that comes out, it's just one piece that comes out to lot, goes through the building department and HCD, and we do the utilities and foundation. Mobile home is like your travel trailers done by the DMV, so it's similar. And like I said, the factory-built housing is components that are built in a factory. They get a quality control review, but they still go through the local building department and require plans like a stick built. The modulars come in typically 2 or more pieces, and have to be built together. So they're like a manufactured home, but they're bigger and have different requirements and are installed that way. So I don't know if that helps, but that's how it's handled.
The reason I ask is because of the housing problems we have. More and more developers are going to pre-manufactured, factory-built homes. So they come out in the trailer, and then the contractors, the GCs, assemble them with their subcontractors in the field, but they come complete. So it's a complete unit, and they just put them, they go together like Legos. So they got them they're starting to build them in Oakland and San Francisco.
Yeah,
Yes.
they bring them back to factory build.
Yeah,
They-
but they also aren't under the California Building Code either.
Right.
Okay,
So the
guys,
state inspectors check them out, and then the
I've
local
been advised
inspectors
we're
check 'em out.
going off the agenda, so
Oh.
I'm gonna need you guys to either
Okay.
stick to the topic, or we're gonna go on to C3.
That's our enforcement update that's next, correct?
Well, the enforcement was under.
We've been a little bit all over.
Enforcement would be C4.
I believe we're on C3, the discussion regarding proposed improvements for CSLB and
Original
NSCB.
license.
Okay.
Ms. Mathias?
And Justin Paddock.
We put together just a brief handout. It's in front of you for those in the audience. It's over here on the table. I think we've touched on a lot of these already just in the prior robust discussion, but I'll hand it over to Nancy to walk through.
Great, thank you. First, I wanted to thank Justin for putting together the handout materials that outline each of our state's efforts. Thank you for doing that. As we've been sharing some of the ideas and challenges that we've had, it's been clear that both of our states have identified the need to revisit our application forms with the goal of receiving complete and accurate information. As Nevada took on this project, one thing we realized is that over the years, we really tried to pack too much informational material in our application form, thinking that that might be helpful. But it really wasn't. So we really started by paring down the informational text, and we're trying to just focus on the requirements, key requirements for obtaining a license. Basically telling the applicant what they need to do and not necessarily explaining why they need to do that. Another problematic area for us was the information, or more accurately, the lack of information that we receive on the reference certificate forms. More often than not, they'll say something like, he or she is a great person. So-and-so would make a great contractor. But they weren't specific as to the actual type of experience, trade-specific experience that this individual had. So we modified that form to require our applicants to indicate on the form the classification or the scope of work that they intended to perform. And then we asked the certifier to specifically speak to that. We have had some success with that, but that area still continues to be somewhat of a challenge for us. We also modified our background disclosure statement. We consolidated a number of the questions, especially as they relate to criminal histories. We were asking about 3 or 4 different questions, whether they've been convicted of a misdemeanor. Have you been convicted of a felony? And it kind of went on and on. Now we simply ask whether or not the individual's been convicted of a crime or if they have charges pending against them, yes or no. Based on what we find out in our background investigation, then we will ask for subsequent information if we find a criminal history. This has saved a great deal of time in addressing either real or perceived misrepresentation issues, and also trying to have applicants resubmit corrected forms. And so we think that's been helpful as well. Like California, we're also working toward an online application process. So we look forward to sharing those challenges and ideas as well. And then last we also worked at enhancing our online renewal application this last year. We tailored the form. It's more intuitive now, and we've tailored it toward the individual licensee requirements. Our prior online program was tried to be a one-size-fits-all, and so it was confusing for the users, and this has been much more effective. We also started sending out with our renewal notices the name and contact information for a designated staff member so that the licensee can call and that individual can help them set up their online account and then walk them through the process if it's their first time using the online renewal. That's been very well received and effective as well. This past year, we've increased usage by about 15% with those programs, and look forward to seeing increased usage in the future as well. So, thank you.
As Nancy referenced, we're really excited about working on updating our application. I think not many would debate with me that the current application that California provides to contractors is really complicated and can be confusing. And it's led to a lot of errors where we have to actually work with the applicant to make sure everything's filled out appropriately. To that end, two individuals at CSLB have spent countless hours, Charlotte Allison and Claire Goldstein, on making a user-friendly application. They've done a remarkable job. It's not a perfect analogy, but the way that they've designed it is very similar to how TurboTax will walk you through your taxes each year. You just go through phases of filling out the pertinent information, making sure that it's accurate, and then you move on to the next piece of information. And at the end of that process, the form gets populated according to the responses that you gave. We're hoping that this is going to greatly reduce errors. Another very interesting thing is when you get to the experience requirement piece of the application, you're going to actually be creating a reference as opposed to having someone else certify that particular information. So on the current application, if I worked for Nancy, Nancy would have to actually fill out the work I had done for her and then sign at the bottom. What will happen in the future is I'll fill out the work I did for Nancy and then provide Nancy's contact information so that if there's any questions, et cetera, she can be contacted to confirm that those were the individual things that I had done for her. In addition to that, a lot of applicants have difficulty on what we're looking for when we're looking at the experience portion. We're going to be providing examples of this is a great way to explain it for a B. This is an okay way to explain it for a B, and this is really a poor way to explain it for a B, and we'll need more information. We're hoping by providing some examples that will also help applicants. Right now, we're finalizing the initial screens. We are certainly trying to fast track this as best we can, and we hope to get it out. My hope is in 2020. I can't fix it on a certain date yet. With that, we will move to other transactions that we do. One of those would be address change forms, our renewals. The long-term plan is to make sure all transactions go online and are following this process where you're answering specific questions and then it will populate the form for you. In addition to that, just because I think Nancy also referenced online renewal, we are going to be working on that, but I don't have a fixed release date for that at this time. One other thing that we have done recently is move our asbestos examination online. Each contractor needs to needs to review material and then complete a test on some basic asbestos information. The critical reason for this test is just to make sure when you're going through a wall or you're in an attic, you can quickly identify that you have an issue, and then you can call the appropriate entity to help you resolve that issue so that everyone stays safe. That examination is now online for the first time. It's actually the first thing we took a stab at. You review the material, you log in, you complete the examination. If something's incorrect, it'll tell you, no, this is incorrect. You need to go back to this specific portion of the material, review it, and then try again. And once you complete that exam, it actually populates on our licensing system so that no person has to actually see a piece of paper or do any sort of processing. It's just automatically done. in the long term, we're hoping all of our transactions go that way.
We're going to take a quick 5-minute break. It is now 10:04. We will resume at, it's 10:11. Yes.
I'm so sorry. I just assumed there may be questions, but I did want to take a moment and just, this is my first year with the Contractors Board, and I need to personally thank Nancy. She has made herself available and has been extremely generous with her time in this past year, and I've really appreciated it. I assume the Nevada Board already knows how great Nancy is, but I want to make sure the California Board did as well.
We do.
Thank you. See you in 5.